Hi, my name is Austin Leake, and I did the Mossner versus Atlantic City Country Club case. A little background on the case. All right, so it started at approximately 7:30 a.m. on Sunday, March 28th, 1993, when plaintiff Spencer Van Mossner, who happened to be a longtime member of the Atlantic City Country Club, arrived at the golf course with his friends Michael McHugh, Robert Dews, and Peter Costanzo. These four regularly golfed together on Sunday mornings. Even though a snowstorm had been predicted for this particular morning, the four men were not scared away from their Sunday morning outing. The sky that morning was overcast and conditions were misty, and by the time the four men began to play their golf round, it was drizzling. At approximately 8 a.m., the club's starter directed the men to tee off on the 10th hole. The group got through holes 10 and 11, and then the drizzle turned into a complete downpour, which began to slow down as they teed off on hole number 12. After hitting his approach shot on the 12th green, Michael McHugh noticed a lightning bolt, and the four players and their two caddies began to head back to the clubhouse to seek refuge, which happened to be a half-mile away from where they were at on hole 12. Along this route back to the clubhouse, there were no man-made shelters available. While walking, the plaintiff put up his umbrella in order to avoid the rain, which you can probably guess what happened next. En route to the clubhouse, the group crossed onto the 7th fairway. Walking on the 7th fairway, McHugh and Dews were about 15 yards behind the plaintiff and Costanzo. Suddenly, there was an extremely loud noise, and McHugh watched as a lightning bolt struck the plaintiff, causing him substantial injuries. Both the plaintiff and Costanzo fell to the ground. Dews immediately went to the clubhouse for help, which is approximately 325 yards away, while McHugh remained behind to assist his friends. One caddy was sent to a nearby police station to obtain additional assistance. After asserting that Costanzo was stable, McHugh administered CPR to the plaintiff until the police and medics arrived. According to McHugh, the club caddy master and club pro arrived at about the same time as the police. During this time, lightning continued to appear in the sky. In his complaint, Mossner contended that a lightning strike on a golf course is a foreseeable risk that must be addressed by the owners of the course where various means of protection are feasible. Specifically, Mossner alleged that the golf course was unsafe for golfers because the club, 1, did not use available lightning detection equipment, number 2, did not make proper use of various weather reporting services, number 3, did not provide shelter at convenient spots throughout the course, number 4, they did not have an effective evacuation plan, and finally, number 5, they did not adequately warn golfers of the hazards of lightning. In the opinion of Mossner's expert witness in recreation safety, the lightning was a dangerous condition in the design, management, and maintenance of the country club, created and exposed Mossner to the risk of being struck by lightning. Moreover, plaintiff's experts stated that this accident could have been avoided if proper weather monitoring was used by the club. At this time, weather service personnel had the technology to foresee these conditions that would have resulted in storm fronts producing lightning. There was technology available, known as SkyScan, in 1993 to the Atlantic City Country Club that would have enabled personnel to detect lightning up to as much as a 40-mile radius of the country club. This technology was available at a reasonable, minimal investment to the country club. It was portable and would have provided more time to institute an evacuation plan for golfers as well. The club should have had a better system for warning the golfers of the need to evacuate the golf course by use of an audible signal. In response to Mossner's allegations of negligence, the country club asserted that it had used reasonable care to make its premises safe for golfers. Specifically, the club claimed as follows that it monitored the Weather Channel and was in constant communication with the weather station. Club management generally monitored the weather by listening to the Weather Advisory Channel and placing calls to the Naval Aviation Facilities Experimental Center, also known as the NAFEC. The club consulted the National Weather Service on the morning of the incident, and although inclement weather was predicted, there were no warnings that lightning would be possible for the day. Club members were warned about the general risk of lightning by a notice from Don Siak, the club golf pro, and a United States Golf Association poster, which were both posted in the locker room. The notice from SIOC advised golfers that Weather conditions sometimes necessitate our golf course evacuation plan to be implemented when authorized personnel advise you to come in off the course. It is imperative that you do so. Our weather monitoring system advises us of dangerous elements in the area and gives us time to clear the course to ensure your safety and evacuation. The USGA recommends you react immediately to a dangerous situation and seek shelter if you feel danger from lightning or storm is imminent. Based upon this evidence, the trial court granted summary judgment to the club dismissing Mosner's case. In the opinion of the trial court, the owners and operators of a golf course owed no duty to golfers to protect them from lightning strikes. In granting summary judgment to the club, the trial judge stated as follows: I don't find any of the case law any duty on part of the country club to protect against acts of God. The storm, or the lightning portion of the storm at least, appears to have been unanticipated. Whether it was or not, when the first lightning bolt struck, it was equally visible to the plaintiff as it was to the pro or the assistant pro at the clubhouse. And he chose to expose himself by walking across the open fairways, heading back to the pro shop with an umbrella. The judge indicated that he did not see that anything the country club did, even if it might have been considered negligent or less than optimum, caused this injury to the plaintiff. The judge found that the proximate cause was, first of all, an act of God, the lightning, and secondly, his own activities in exposing himself to the possibility of being struck by lightning.